This is what happened when Florida eliminated permanent alimony through Senate Bill 1416 after decades of failed attempts. Women filing for divorce in Florida in 2026 face a completely different set of rules than those who divorced just 3 years ago. And understanding these changes could determine whether you walk away with financial security or find yourself struggling to make ends meet. We're going to break down exactly how alimony works in Florida today, covering who qualifies, how much you can receive, how long it lasts, and what factors courts consider when making these decisions. If you've spent years prioritizing your family over your career, these new rules directly impact your financial future, and they are much more restrictive than they used to be. Let's be absolutely clear about what this reform did when it took effect on July 1st, 2023. Courts in Florida can no longer award lifetime spousal support, and if you file for divorce on or after July 1st, 2023, permanent alimony is not on the table. This is the most significant change in the entire law and the one that gets the most attention. For decades, Florida was one of a handful of states that still allowed judges to order one spouse to pay the other for the rest of their life or until the recipient remarried. But that's gone now. Senator Joe Gruters, who sponsored SB 14116, argued that permanent alimony was outdated, though groups like the First Wives Advocacy Group strongly opposed these changes. Here's what the law did not do, and this matters. It did not automatically convert existing permanent alimony agreements. Your divorce finalized before July 1st, 2023, and you're receiving permanent alimony, you still receive it because the law is not retroactive. That said, your ex-spouse can seek modifications by going to court and asking for the alimony to be reduced or terminated. He can't just point to the new law and say he wants out, as he needs to show that something significant has changed in his financial situation, his health, or other relevant factors. So if you're receiving permanent alimony from an old agreement, you're not automatically safe from changes, but the burden is on him to prove why it should be modified. For everyone else, for every divorce you file after July 1st, 2023, Florida now operates under a time-limited system alongside equitable distribution of marital assets. And that brings us to the 4 types of alimony that still exist. Florida recognizes 4 types of alimony under the current law, and each serves a different purpose with different rules and different time limits. First, Bridge the Gap Alimony. This is short-term support designed to help you transition from married life to single life with a maximum duration of 2 years. You cannot get Bridge the Gap Alimony for longer than 2 years, no matter what. The purpose is to assist with legitimate, identifiable short-term needs, like covering rent and utilities while you're getting back on your feet or handling immediate expenses during the transition period. The needs have to be specific and identifiable, not speculative or long-term. Here's what makes Bridge the Gap unique. It's non-modifiable, meaning once the court sets the amount and duration, neither you nor your ex can go back and ask to change it. It only terminates if either of you dies or if you remarry, and otherwise it runs its course exactly as ordered. The court will only award this if you have a genuine, immediate financial need, and if you're presumed capable of supporting yourself after the award period ends. Second, Rehabilitative Alimony. This is support designed to help you redevelop skills, education, training, or work experience so you can achieve self-sufficiency, and the maximum duration is 5 years. Rehabilitative alimony requires something specific, a detailed, defined rehabilitative plan that must be included in the court order. It needs to outline exactly how you're going to achieve self-sufficiency. Let's say you stepped away from your nursing career to raise your kids. The plan would detail how you'll renew your license, complete any required continuing education, and return to work as a registered nurse within a specific time frame. Sometimes this process involves working with a vocational evaluator to assess your skills and job market prospects. The plan must be realistic, measurable, and completable within 5 years, and the court has to approve it. Unlike Bridge the Gap, Rehabilitative Alimony can be modified or terminated early. Complete the plan ahead of schedule, and your ex can ask the court to end the payments. Don't comply with the plan, and he can ask for termination. A substantial change in circumstances means either of you can seek modification under Florida Statute 6114, third, Durational Alimony. This is economic assistance for a set period following marriages of short, moderate, or long duration, and this is probably the type you'll encounter most often. First, you need to know that durational alimony is only available if your marriage lasted at least 3 years. Marriages under 3 years cannot receive durational alimony at all. The duration of durational alimony is capped based on how long you were married, and here's how it breaks down. Marriages lasting less than 10 years are considered short-term, and the maximum duration of alimony is 50% of the length of the marriage. Marriages lasting 10 to 20 years are moderate term, and the maximum duration is 60% of the length of the marriage. Marriages lasting 20 years or more are long-term, and the maximum duration is 75% of the length of the marriage. Let me give you examples. 8 years of marriage is short-term, so the maximum alimony duration would be 4 years, which is 50% of 8. 15 years of marriage is moderate term, so the maximum would be 9 years, which is 60% of 15. 25 years of marriage is long-term, so the maximum would be 18 years and 9 months, which is 75% of 25. Now, these are maximum caps, not guarantees. The court can award you less or award nothing. And these numbers represent the ceiling, not the floor. Exceptions exist where the duration can extend beyond these caps, if there's clear and convincing evidence that it's necessary. A disability that limits your ability to support yourself, or an age that makes it unrealistic for you to re-enter the workforce might convince the court to extend the duration, but the burden is on you to prove it with clear and convincing evidence, which is a high standard. One more thing. Marriage length is calculated from the wedding date to the date you filed the divorce petition, not the date the divorce is finalized. Fourth, temporary alimony. This is support paid only during the divorce proceedings and ends when the divorce is finalized. Its purpose is to maintain some financial stability while your case is pending. And we won't spend much time on this one because it's straightforward and it's not part of the final divorce judgment. So we've covered the types and durations, and now let's talk about the amount and how much alimony you can actually receive. Florida law caps alimony at 35% of the difference between the spouse's net incomes. And let me explain what that means. First, it's based on net income, not gross income. So net income is what you take home after taxes. The court looks at both your net income and your spouse's net income and calculates the difference. Let's say your spouse has a net income of $6,000 per month and you have a net income of $2,000 per month. The difference is $4,000, and 35% of $4,000 is $1,400, which is the maximum monthly alimony you could receive. But here's the catch. The amount is the lesser of two things. Either your reasonable need or 35% of the income difference, whichever is lower. So even if 35% of the income difference is $1,400, if the court determines your reasonable need is only $1,000, you'll get $1,000. The court has to find that you actually need the money to maintain a reasonable standard of living. Income includes more than just salary and covers income from both non-marital and marital assets. Investments, rental properties, or other sources of income all count. Now, what if your spouse is deliberately unemployed or underemployed to avoid paying alimony? Or what if you're capable of working but haven't returned to the workforce yet? This is where imputed income comes in, as courts can assign income based on earning capacity. If your spouse is voluntarily underemployed or unemployed, the court can impute income to him based on what he could be earning. The court looks at several things: his prior earnings history, his skills and education, his recent work history, labor market data like median wages for his field, and sometimes vocational evaluations. Case examples exist of courts imputing $104,131 to an ex-executive who claimed to be unemployed and imputing $17,850 to a part-time parent caretaker. The point is, he can't game the system by artificially reducing his income, as the court will look at what he's capable of earning, not just what he's currently earning. But this applies to you as well. If you're seeking alimony, but you're capable of working, and you're not, the court might impute income to you, which would reduce your need and therefore reduce your alimony award. If you have a college degree and professional experience, but you've been a stay-at-home mom for 10 years, the court will consider both your past qualifications and the realistic challenges of re-entering your field after a decade away. Before a court even considers how much alimony to award, or for how long, it has to determine whether you qualify at all. And this is a two-step process. Step 1. The court must find that you have an actual need for support and that your spouse has the ability to pay. Can't demonstrate that you need financial assistance? The case is over, and it doesn't matter how long you were married or what you contributed to the marriage, because you have to show actual need. Similarly, if your spouse doesn't have the ability to pay, even if you have a need, you won't get alimony because the court can't order someone to pay money they don't have. A case from 2025 called Fraser v. Dodd illustrates this point. The wife was awarded $1,500 per month in alimony, with her income at $2,803 and the husband's at $6,371. But the appellate court reversed the award because there was insufficient evidence of the wife's actual need. The income difference existed, but the court didn't find clear evidence that she needed the support. The lesson here is that need must be proven, and you can't just assume that because your spouse earns more, you're entitled to alimony. Step 2. If need and ability are established, the court then considers the statutory factors. Florida Statute 61.08 lists the factors courts must consider when determining the type, amount, and duration of alimony. So let's go through them. Factor of the marriage. We've already covered this, with short term being less than 10 years, moderate term being 10 to 20 years, and long term being 20 years or more. Factor B. Standard of living established during the marriage and the anticipated needs and necessities of each party after the judgment. The court looks at how you lived during the marriage and what it will take for each of you to maintain a reasonable standard of living after divorce. This doesn't mean you're entitled to the exact same lifestyle, but it's a consideration. Factor C. Age, physical, mental, and emotional condition of each party. This includes whether you're physically or mentally disabled, the impact on your ability to provide for your own needs, and whether these conditions are temporary or permanent. 60 years old with health issues that prevent you from working? That's going to weigh heavily in your favor for alimony. 30 and in good health? Less so. Factor D. Resources and income of each party. This includes income from both non-marital and marital assets. So if you have significant assets or income sources outside the marriage, that reduces your need. Factor E. Earning capacities, educational levels, vocational skills, and employability. This is where the court assesses your ability to obtain necessary skills or education to become self-supporting and your ability to contribute to your own support. A college degree and work experience means the court will expect you to use those skills. But if you've been out of the workforce for 20 years raising children, the court will consider that too. The reality is that re-entering the job market after years as a stay-at-home parent is challenging, and courts do recognize this when evaluating your earning capacity. Factor F. Contribution of each party to the marriage. This includes homemaking, childcare, education, and career building of the other spouse. Put your career on hold to raise children while your spouse advanced his career? That's a contribution the court will recognize. Supported your spouse through medical school or law school? That counts. Managed the household so he could work long hours and travel for business? That matters. Factor G. Responsibilities for minor children in common, custody of young children, especially disabled children, affects your ability to work and your need for support. Factor H. Tax treatment and consequences to both parties. This was listed in the 2022 version of the statute, and tax implications can affect the real value of alimony payments. Factor 1. All sources of income, including investments. Again, the court looks at the complete financial picture, not just salary. Factor J. Adultery of either spouse and its circumstance. Now, this one requires clarification because Florida is a no-fault divorce state. You don't need to prove adultery or any other misconduct to get a divorce. But adultery can affect alimony, though only in terms of economic impact. The court is not making a moral judgment and is not punishing the cheating spouse. What it's looking for is whether the adultery caused financial harm to the marital assets. So did your spouse misuse marital funds? Did he hide accounts? Did he make unusual expenditures on the affair? Emotional distress or betrayal alone is not enough, as you have to show economic harm. A spouse who committed adultery can still be required to pay alimony if you meet the need requirements because the adultery factor is about financial impact, not punishment. One of the significant additions in the 2023 reform is the codification of retirement as a valid ground for modifying or terminating alimony. And this is something you need to understand because it could affect your long-term financial security. Under the new law, your ex-spouse can apply for modification no sooner than 6 months before his planned retirement. And this applies to all alimony awards, including pre-2023 awards, as long as he can prove a substantial change in circumstance. Before this law, retirement modifications were governed by case law, like the 1992 Florida Supreme Court case Pim v. Pim, but now it's explicitly written into the statute. When a court considers a retirement modification, it looks at several factors: the age and health of your ex-spouse, the customary retirement age for his occupation, the economic impact on you, and the likelihood and motivation of him to return to work. The law also references normal retirement age, which aligns with Social Security definitions, and if he's reached normal retirement age, it's easier for him to seek a reduction in alimony. But he still has to demonstrate substantial, unanticipated financial changes from retirement, so he can't just say he's retiring and therefore done paying. He has to show that his income has significantly decreased and that he can't afford to continue the payments. For you, this means that even if you're awarded alimony for a certain duration, it could be reduced or terminated if your ex-spouse retires, and that's a risk you need to be aware of when planning your financial future. More broadly, alimony can be modified if there's a substantial change in circumstances, and this is governed by Florida Statute 6114. Rehabilitative alimony can be modified based on plan completion or non-compliance. Durational alimony can be modified with proof of substantial change, and pre-2023 permanent alimony can be modified with proof of substantial change. The one exception is bridge the gap alimony, which is explicitly non-modifiable. Let's bring this back to practical terms. If you're a woman considering divorce in Florida in 2026, here's what you need to understand. You have to prove actual need before the court even considers anything else. This means gathering your financial documents, demonstrating your expenses, and showing exactly why you can't meet those expenses on your own. If you've been out of the workforce, the court will expect you to take steps to become self-sufficient. This can feel incredibly overwhelming if you've been a stay-at-home mom for the last 15 years, but that's the reality of the current law. However, your contributions to the marriage matter. If you sacrificed your career to raise children or support your spouse's career, that is a factor in your favor. Document it, be specific, and keep records of how you supported the household. The reality is that this reform has been particularly challenging for women who spent decades as homemakers, as you're now expected to achieve self-sufficiency within a limited time frame. The 2023 changes completely rewrote the rules for alimony in Florida. I want to hear from you. Do you think these new strict time limits are fair? Or do they punish spouses who stayed home to raise the kids? Let me know your thoughts in the comments below. If this breakdown helped you, hit that like button, subscribe to the channel, and I'll catch you in the next one.